Mindy, I turn on closed captioning, but I will tell you that it is not accurate a lot because it'll show that I'm cursing.
Oh,
And it'll show curse words and I am not cursing, but it's kind of funny. So, good morning, Miss Underwood.
good morning, Your Honor.
All right, so I have somebody on an iPhone walking. Could you go ahead and unmute your device and let me know who you are?
Yesenia Hernandez.
All right, let me find you here.
I have court at 8:30. I'm on a little bit early.
It's okay. I'm gonna change your screen name so that I remember who you are. And then, you have Mr. Kavajian, correct?
Yes.
All right, so I just changed your screen name. I did put his name after yours. I'm gonna pop you in the waiting room and there she's here. Okay. So, Ms. Underwood, nobody's appeared for the 8 a.m. hearings, just so you know.
Okay. I think
And it's not
I have
yet.
a Demulin show cause for a VOP. I probably have not been appointed yet.
So I told you I have 2 VOPs and
Okay.
none of them have showed up yet.
Okay. And then I have a Michael Newsom AG pretrial at 8:30 with you.
Okay. Well, I can call Demulin now, but he hasn't appeared, so.
Well, then I think I'm going to go down the hall and see if I can get anything done down there, Your Honor.
Okay, Judge Olsaver does have a jury trial today, so I go ahead and make sure you get him taken care of first.
Thank you.
Thank you. All right, I'll be right back. Last probation results. Good morning.
Morning.
So I'm gonna put the courtroom in the waiting room for a minute. What is your name? Okay. And all right, and you're here to watch, right? For Adams? Gosh, look at that. Mine like traps sometimes I have. I know. All right, let me see. Okay. Put in person. So I will tell you that the judge next door has a jury trial starting today. So I always let the attorneys go to him first so that his trial gets started on time. Mr. Mai, good to see you.
Morning, Your Honor.
I'm always glad to see when our husbands introduce themselves as our husbands. Your husband introduced himself yesterday as Katerina Dumont's husband, and my poor husband has to do that too sometimes.
Everybody
Probably 'cause I
thinks
keep
his last
calling him
name is
Mr. Dumont.
Yeah, that's what everyone thinks his name is.
Hi, this is Judge Anselone, so I am ready for.
Follow me over here. How you doing this morning?
I'm good, how are you?
All right.
I am ready for, let me see who I got here. Christopher Cundiff.
Okay.
And that's all, I have Matt Murphy, so I'm ready on Noah Lamley as well.
Lamley,
Yes, sir.
I think he may be, okay. All right, let me gather them and get them on there.
All right, thank you. Bye. And Mr. Dagger Margosian goes to that courtroom first and then to mine, so it'll be just a minute, okay?
Remember here, I didn't know how to do Zoom, so that's why I did it in person.
Not a problem. Not a problem. We are always open. All right, Attorney Ramsayer, can I ask what case you're here for today?
Burton Harlow, Your Honor. Good morning.
Burton Hart, okay. What's the last name?
Harlow, Harlow.
Yep, okay. Yep, it's not quite 8:30, so let's see. Michelle Harding. H, I assume you are Michelle Harding, is that correct? Okay. Okay, this is in the matter of the people of the state of Michigan versus Joshua DeMullen, file number 25-22183. This is the date and time set for a show cause. Mr. Request and summons for probation violation was mailed out on June 25. Mr. DeMullen has failed to appear. Failed to report for orientation as well as report day. On the issue of bench warrant for his arrest and set bond in the amount of 25,000 cash. Okay. In the matter of people of the state of Michigan versus Jason Crone. I have two files. 23-21520 FH and 24-21715 FH. Says the date and time set for a request and summons for probation violation. That's weird. He's failed to appear, so I'm going to issue a bench warrant and set bond in the amount of 25,000 cash on each file. All right, I have somebody on a device that says Michelle H. What is your name, please?
Michelle Harding.
That's what I thought. So I'm going to change your screen name so it says Michelle Harding and then
Okay.
/Fry. So I remember who your attorney is.
Okay.
I am going to put you in the waiting room, and when he gets here, I'll bring you back in. Okay.
Okay. Thank you.
Thank you. In the matter of, well, that's a Sam case. I'll wait on that one. All right, so I have a couple gentlemen in jail rooms. If you look behind you, there's a number. So who is in jail room 4?
Christopher Cundiff.
All right, let me grab your file. This is in the matter of the people of the state of Michigan versus Christopher William Cundiff, file number 25-22319 FH. I have, I don't know whose P number is lower, but I'm gonna go alphabetically. So I have Alexander Bayonetto appearing on behalf of the people, but I think Ms. DeMont beat you out. And I have Katerina DeMont appearing on behalf of Mr. Cundiff. This is the date time set for arraignment in this matter. I do, Ms. DeMont, as always, thank you. I do have an advice of rights and a plea agreement form. And so Ms. DeMont, do you waive the reading of the felony information?
Yes, Your Honor. And we would like to enter in into a plea.
All right. So as I said, you've already provided the advice of rights. That's awesome. And then I have a plea agreement form that states that the defendant will plead guilty to an added count 2 felonious assault, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine. If he is eligible, he can be sentenced under the Homes Youthful Training Act. Count 1 will be dismissed at the time of sentencing. Let me look through here. And I don't see any other terms to that agreement. Is that correct, Ms. DeMont?
Yes, Your Honor. And then we would just like to address bond after the plea.
All right. So Mr. Cundiff, if you want to raise your right hand for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Can you state your full name for the record, please?
Christopher William Cundiff.
All right. So Mr. Cundiff, you have heard the statement. Well, you heard me read the plea agreement form. And Mr. Bayonetto, I know this is a Mr. Sneed case. Is that a correct recitation of the plea?
It is, Your Honor, yes.
All right, so Mr. Cundiff, you've heard the plea agreement. Is it your intention then to plead guilty to account to felonious assault, which carries a maximum penalty of up to 4 years in prison and or a $2,000 fine?
Yes, Your Honor.
And you understand if you are eligible, I will sentence you under the Homes Youth Load Training Act.
Yes, Your Honor.
All right, so are you satisfied with Ms. Dumont and the advice that she has given you?
Yes, Your Honor.
All right, and I'm gonna apologize in advance. We got air quality is really bad here because of the fires and, you know, allergies, so I may have to pause, but neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Dumont? You're muted, Ms. Dumont.
Yes. Yes, Your Honor.
All right, is that correct, Mr. Bayonetto?
It is, Your Honor.
And Mr. Cundiff, is that correct as far as you're aware?
Yes, it is, Your Honor.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
Yes, Your Honor.
Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310, between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing agreement, or otherwise failing to comply with an order of the court pending sentence. So, Mr. Mott's probably going to be asking for you to get out on bond. So if you get out on bond and you commit a new crime or you assault somebody or you don't report for bond conditions to Mr. Coast, then I will not have to sentence you in agreement with the agreement. So I could send you to prison. I could do any number of things, and you understand you wouldn't have a right to withdraw your plea.
Yes, I do understand that, Your Honor.
All right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, I do not.
All right, so I don't think I have an amended yes, I do. All right, so I didn't have an amended information, just it was already amended before it came up, I think. So how do you wish to plead to the charge that on or about June 12 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense listed under count 2, assault with a dangerous weapon? Guilty or not guilty?
I'm guilty.
Okay, has anyone made any threats or promises to you to induce you to plead guilty to this offense?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Mon?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Has your attorney promised you any particular sentence or estimate what your sentence will be in terms of fines, costs, incarceration, or length of probation?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, it is, Your Honor.
All right, so Mr. Cundiff, on June 12 of 2025, were you in the city of Adrian in the county of Lenawee?
Yes, I was.
And were you in the presence of a Christopher Lee Tucker?
Yes, I was.
All right, and did you have mace?
Yes, I did.
And did you assault him by spraying mace at him?
I did, Your Honor.
Okay, but you didn't intend to kill him or inflict any great bodily harm, correct?
No, definitely not, Your Honor.
All right, are you satisfied, Mr. Bayonetto?
Yes, Your Honor.
All right. Except, has the court complied with MCR 6.302 B, C, and D? Ms. Dumont?
Yes, Your Honor.
Mr. Bayonetto?
It has, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them, other than the Killebrew agreement that was placed on the record. I am going to refer this matter to the probation department for a pre-sentence investigation.
Your Honor, before the court gives a sentencing date, I think there's some additional things I think Ms. Dumont and I would both like to place on the record. This agreement was made and Mr. Cundiff waived his exam prior to Mr. Cundiff cooperating with the people in the Trenton Berry case. Mr. Cundiff is currently cooperating in that case. Ms. Dumont and I have discussed a bond reduction. Again, any plea discussions regarding the plea that was just entered, those were all in place before Mr. Cundiff began cooperating. They were not made with the understanding that he would cooperate. However, I think given that cooperation, it would be our request to have this sentencing maybe sometime in December after the Trenton Berry trial has concluded. I did speak to Ms. Dumont about that last night. She didn't indicate that she had any objection to the sentencing date being put out that far. And then I would defer to her as to the bond reduction she's going to be asking for whenever the court feels that's appropriate.
All right, Ms. Adams, would December 12 or 11 or 12 be a good day for sentencing?
Yes, December 12th is good.
All right. So I'm going to set sentencing for December 12 of 2025 at 8:15 in the morning. I do have hold on. What case are you on, Mr. Hartwing?
I'm on Ms. Hernandez, gentleman in the lower.
So I have Mr. Kavajian and Ms. Hernandez is in my waiting room, so I'll call that one next. All right, I do have a pretrial assessment that I received from Darren Coast. He's been in jail since June 12 on a $25,000 bond. He is currently on probation for disorderly in district court. He may also be on probation in Williams County in Ohio. Is that correct, Ms. Dumont?
Yes, Your Honor.
Okay. He scored a 4 on the assessment, which puts him kind of in a moderate range to pick up a new offense or not show. He's been arrested a lot lately and wasn't employed at the time of his arrest. He is living with family and not been making good decisions. So, Mr. Cundiff, you understand your attorney, you're asking for a PR bond, right, Ms. Dumont?
Yes, Your Honor. I spoke with the prosecution. They would agree to stipulate to a PR bond with the tether. He does have a pending DV case in district court that includes his brother. We've spoken with the family and prosecution, and I believe that case will be dismissed. So he is able to return to that address with his family with a tether.
All right. So, Mr. Cundiff, again, if I release you on a PR bond with a tether, I probably will, Miss Adams, is Mr. Coast around somewhere?
Yeah. I will check.
So give us just a minute. Usually we put the tether on you, but you might be being held on stuff in district court, right, Mr. Mont?
I don't believe so. I don't believe there's any holdups.
I actually just was going to send a message to Ms. Dumont. I'm going to dismiss that domestic violence case today. So there shouldn't be an issue with a no contact order for that. The victim in that case is his brother. His brother did request a dismissal, and his brother was actually charged out of the same facts and circumstances. So that case will be wrapped up today. So there shouldn't be anything holding him as it relates to that.
All right. So, Mr. Cundiff, is someone going to help you pay for a tether?
Yes, Your Honor. My father said he'd be willing to pay for that as soon as it was needed.
Okay, well, you're very lucky your father is willing to do that. So I'm going to set sentencing for December 12 at 8:15 in the morning. Now you do have the right to appear via Zoom or in person. Mr. Bianetto, do you have a preference?
No, Your Honor.
All right, so would you like to appear in person or via Zoom, Mr. Cundiff?
I'll appear in person.
All right, so I'll put it in person. I will make sure Mr. Coast, oh, here's Mr. Coast. So we'll bring Mr. Coast in. All right, Mr. Coast, I am going to be releasing Mr. Cundiff on a PR bond with a tether. His family will be paying for the tether. I will require him to check in with you. Sentencing is being set out to December. They'll put the tether on him before he's released from the jail, correct?
That is correct, Judge. And
All right,
is his family here today?
Not in the courtroom, but.
No.
So, Mr. Cundiff, a couple things. Do you want to breakout room with them real quick to get a phone number or anything?
Sure, Judge. I'd appreciate that.
Okay. All right. So, Mr. Cundiff, in a minute, I'm just going to put you in a breakout room with Mr. Coast. He's going to get some of your family information to reach out to them about the tether process. You will have a tether placed before you're released from the jail. When you are released from the jail, Mr. Coast will give you instructions on how to report with him through December. After you talk to Mr. Coast, you also need to go to the, let me find, Chris Jones, do you want him just to report to the probation department today?
Yeah, that's fine, whenever he gets released.
Okay, okay, so when you get out of jail, I need you to come up to the third floor, meet with Darren, and then you're gonna have to report to the probation department, and then they'll get your information and give you instructions. When you meet with the probation department, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Ms. Dumont, and then we will see you back here on December 12th at 8:15 in the morning. Remember, if you get in trouble while out on bond, because you've been getting in trouble lately, then your agreement's out the window. I don't have to give you HIDA. I could send you off to prison. You understand? So you better behave.
Yes, I understand, Your Honor, and I appreciate you taking the chance with me.
Okay, thank you.
Thank you, Judge.
Thank you.
All right, you can go ahead, Mr. Cundiff, you're all set.
All right, thank you.
And let's see. Everybody's like, what wildfires? And they're like, in Canada, and it just blows right down on us. All right, let me get your client. She's in the waiting room, and then I'll hop back to you, Mr. Murphy. So, Windows. All right, Ms. Hernandez, thank you. So this is in the matter of the people of the state of Michigan versus Yesenia Hernandez, file number 25-22280FH. I have Manny Kavajian appearing on behalf of Ms. Hernandez, and I have Douglas Hartung appearing on behalf of the people. What is this? This might be an arraignment. Let me check.
It's a pretrial.
Oh, it's just a pretrial. So, Mr. Kavajian and Mr. Hartung, how would we like to proceed?
We did have a discussion previously about doing a universal plea deal with her misdemeanor and the felony, wherein the misdemeanor was reduced to disorderly, which we already took care of that one, and then this case was supposed to be resolved with the plea deal pursuant to HIDA. So if that's what we're still doing, I think we're going to be moving forward with that.
That's accurate. On the information, there is a count two. I guess it was added at the time that she was brought upstairs after she waived exam. She would enter a guilty plea to count two. We would have no objection to the HIDA program for Ms. Hernandez. And there would be some restitution that would be determined by the court.
What was count two?
Arson, third degree.
And count one is dropped?
Count one is dropped.
Yeah,
Okay,
count
got
one is second degree arson, which is a 20-year felony, so that would be dismissed. Count two is third degree arson, carries a maximum penalty of up to 10 years and $20,000 fine or 3 times the value, and that's eligible for HIDA?
I believe so.
Okay, he believes it, and I mispronounced your first name, it's Monty, but he said it's eligible for HIDA. So as long as she's eligible for HIDA, there shouldn't be a problem. So is that your understanding of the plea, Mr. Kavajian?
It is, Judge. Would your honor be willing to do a cops to HIDA?
If he has no objection to it, then I will do it as long as she's eligible.
Yeah, that's the plan.
Excellent. I'd really appreciate that.
So that's basically a killabrew more than a cops. So, does your client wish to avail herself of that today? You want a breakout room with her, or?
Yeah, but we could briefly. I just want to explain to her what all that means, but that was our aim. It was to follow through with that, Judge.
Okay, so I'm gonna pop the two of you into a breakout room. Ms. Hernandez, just click join the breakout room. If you can't figure out how to get out of there, don't worry. When your attorney comes back, I will bring you back. So let me find you. There you are. Right, go ahead and join that breakout room. All right, I have a gentleman at the jail. You're the room 5. What's your name, please?
Noah Lamley.
All right, Mr. Lamley, Mr. Murphy. Let me grab Mr. Lamley's file. All right, this is in the matter of the people of the state of Michigan versus Noah Lamley. We have 2 files, 24-22063FH and 25-22205FH. I have Matthew Murphy appearing on behalf of Mr. Lamley, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial. So, Mr. Murphy, how do you wish to proceed today?
Your Honor, we had outstanding the issue as to Mr. Lamley's criminal responsibility in this matter. I received, I believe, I guess the week after the last pretrial. It was dated June 5th when it was created by who was it? Dr. Anaker. I didn't know if the court received that or not, that report. I received it.
I don't have it in my file, but you want to give me the gist of it?
Well, it's the doctor's opinion that Mr. Lamley is criminally responsible for his actions. And I had no objection to, at this point, to that finding. I would have to get a separate doctor, a separate opinion, and file a hearing. I wanted to just talk briefly to Mr. Lamley and then ask for another pretrial if we could, Your Honor.
All right. How far out would you like a pretrial?
Just sort of along, I guess, a few weeks, because I just want the people haven't communicated with me if they've received that. I haven't gotten an offer or what's on the table, what's still open for Mr. Lamley to do in these cases. So that's why
I'm going to set this for another pretrial on August 13 at 8:30 in the morning. And you'll do the stipend order to adjourn. And you want to break out room today with him?
Well, yes, Your Honor, then I wanted to address bond if we could.
Okay, go ahead and address bond. I don't show that we had a pretrial assessment done for him, but let me see here. He's charged with tampering with his tether and MDOP. So go ahead and address bond.
Your Honor, Mr. Lamley has been in custody now since, I believe, March 25th or so, if I'm not mistaken, maybe March 24th. So it has been almost 4 months. In regards to destruction of property, I mean, that case, we're trying to figure that out. And obviously, this incident occurred in regards to the tampering. Now, again, in regards to that, Mr. Lamley has contested that he doesn't recall any of the events that led up to the monitoring device being tampered with or removed. That he was assaulted in the area that he was at, and that's what led to that. But, Your Honor, in regards to this, looking at the cases, if he was to go to trial and get found guilty, I mean, he's already been in custody for 4 months. We would argue that that will be a sufficient custodial sentence with probation afterwards. So we're asking the court to consider releasing Mr. Lamley on a PR bond. At this point, if he was to not appear, he'll be looking at absconding charges, which would make it even more, more an issue with him to deal with moving forward. Again, whether or not there's going to be a trial set in the matter or not, I'm not sure. But again, Mr. Lamley has an extremely incentive not to, fail to appear. So I do believe that he's on a flight risk, Your Honor. Obviously, the incident involving destruction of property, Mr. Lamley, we're trying to figure out ultimately his culpability for that. And in regards to the tampering, we understand, it looks bad in regards to failure to appear, but I don't believe that he poses a threat to the community. At least at this point, again, I believe that, if you look at the report, he's been behaving appropriately. So I'd ask the court to consider a PR bond. I do believe that he'll appear moving forward.
Okay. Mr. Bandetto, you wish to respond?
Yes, Your Honor, just briefly. I believe these are Mr. Lamley's first felony cases that I've encountered him on, but I did have several cases with him in district court. In those cases, he did fail to appear multiple times. Now we have a situation where he was put on an electronic monitor through Monroe for issues that he had stemming out of that county, and there's an issue that it was potentially removed. I would have some concerns that Mr. Lamley would not appear going forward. I would ask that the court not modify bond at this time.
So at this time, Mr. Murphy, I do feel that he has flight risk based on his past history of failure to appear and tampering with his electronic monitoring device. So I'll see you back here on August 13 at 8:30 in the morning. Did you say you wanted a breakout room with him?
I'll Zoom with him later this afternoon. I'm already planning on doing that with some other clients. So I'll just fit him in this
so you can
afternoon.
do this dip in order, and thank you very much.
I'm sorry, was that August 13th, Your Honor?
Yes, sir.
All right, thank you, Your Honor.
All right.
Thank you, Mr. Lamley. I'll talk to you later this afternoon, okay?
Okay, Miss Underwood and Miss Brenner. Let me see here real quick. Is Michael Newsom in the courtroom? Hey, want to come up to the podium, please? Thank you. All right. All right, this is in the matter of the people of the state of Michigan versus Michael Robert Newsom, file number 25-22068FH. This is the date and time set for a pretrial conference, and Miss Adams, if I'll probably either need a notice for whatever adjournment we do today from Mr. Newsom because he's in person. So I have Sarah Brenner appearing on behalf of the Attorney General, and I have Rhonda Underwood appearing on behalf of Mr. Newsom. Ms. Underwood and Ms. Brenner, how do you wish to proceed today with Mr. Newsom?
Your Honor, Ms. Brenner and I have discussed Mr. Newsom. He's paying very well. We would ask for a 60 to 90 day adjournment, Your Honor. And since Mr. Newsom is there in the courtroom, we're happy that the court will do the notice, Your Honor.
Yeah.
He's doing
all right,
really
so I'm sorry, Ms. Brenner.
He's doing really great. I have no objection to the 90 days. He's steadily reducing his arrearages, so he's doing really well.
Awesome. Is this arrearages only?
Yes.
All right, good job, Mr. Newsom. So I'm going to adjourn this out to October 8th at 8:30 in the morning. Miss Adams, could I get a notice of hearing from Mr. Newsom?
Yes, Judge.
All right, thank you. So Mr. Newsom, just have a seat over there on the end of that bench. And we will see you back on October 8th at 8:30 and we'll get you a notice of hearing. All right. All right. Thank you.
Thank you, Your Honor.
I have Mr. Kavajian back, and now I have his client. She should be popping back.
She couldn't figure out how to get out of the breakout room, Judge.
Yeah,
I think
I'm
she
bringing her
was gonna do
back.
it. Okay, thank you.
I got it. All right, so we got Ms. Hernandez back. So, Mr. Kavajian, how would you like to proceed?
Judge, we'd like to move forward. The only addition I would have is that we would like to tender a plea of no contest rather than a guilty plea to avoid civil liability.
Would that be all right, Mr. Hartung?
Well, the other,
Oh, I can't do a no contest for Haida.
not for Haida, and also there's a restitution issue, but I think the plan was to have her plead guilty.
I can't do no contest because Haida has to be a guilty.
Gotcha. Ms. Hernandez, do you understand that, what we're talking about, the difference between the no contest and the guilty plea?
Yes,
Do you want a breakout room with her to talk through what she needs to say, or you good?
I think we're okay, Ms. Hernandez. Are we okay, or do you want to go back in the breakout room so we can talk again?
Yeah, just real quick, please.
Okay, sure.
Okay. All right, so there you go. And okay. All right, so we got Mr. Malaro, Michael Dagger Margosian, your client's right there. Are you ready on him? Or
Yeah.
all right. Let's move the chair council table there for him. That's the only one you have with me, right?
That and Jerome Osborne, who's out in the hall.
All right. I'm going to take this gentleman because he's been here since 8 o'clock. So, and then I'll bob back to everybody else. So, we get Mr. Villarreal's file. So this is in the matter of the people of the state of Michigan versus Philippe Villarreal, file number 24-22055FH. I have Michael Dagger Margosian appearing on behalf of Mr. Villarreal and Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial conference. So, Mr. Dagger Margosian, how would you like to proceed?
Your Honor, good morning, Michael Dagger Margosian for Mr. Villarreal.
Yeah, speak up for me.
This
The
is
microphone's there.
This is a pretrial, Your Honor. Mr. Villarreal is in ECU. He's doing well. I spoke with Ms. McClure yesterday, and we both think that it makes sense to just keep pushing this out so he can complete the program.
October 8th. Is that good?
And 1 second.
You're like so quiet today. That is not normal for you.
I'll speak up.
I have Mindy. She's zooming in. She's my court reporter today.
Oh, I see. That's fine. That date's fine. Thank you.
All right, so we will set this for another pre-trial on October 8th of 2025. Ms. Adams, I do have Mr. Villarreal, so if possible, could I get a notice of hearing for him October 8th at 8:30 in the morning? And I'm gonna put doing well. All right, so stay right there, sir. We'll get you a notice of hearing, all right? Okay. And then so we have, we have her back. Oh, she's on her way back, Mr. Kavajian.
Excellent.
And there she is. All right, so we are back with Miss Hernandez. So I have a note, by the way, from Darren Coast, my pretrial services coordinator, that says she currently has a GPS tether on. She has been compliant and there have been no violation notices. So my understanding is she would plead guilty to count 2 third-degree arson, and if eligible, she would be sentenced under the Home Vehicle Training Act. So is that what your client wishes to do, Mr. Kavajian?
It is, Judge, and then we would also like a moment to address bond, if we could.
Okay, can we do that after the plea?
Whatever's your preference, Judge.
Okay, is that a correct recitation of the plea then, Mr. Herter?
Yes, Your Honor. Count 1 and the habitual offender charge will be dismissed as sentencing.
Okay. All right. So, Ms. Hernandez, do you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Can you state your full name for the record again?
Yesenia Hernandez.
All right, so Ms. Hernandez, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2 third-degree arson, which carries a maximum penalty of up to 10 years in prison and or a $20,000 fine, or 3 times the value of the property damaged or destroyed, whichever is greater? So is it your intention to plead guilty to that charge?
Yes, it is.
You understand, as long as you are eligible, you will be sentenced under the Homes Youthful Training Act.
Yes.
Okay, and are you satisfied with your attorney and the advice that he has given you? All
Yes, I am.
right, so ma'am, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Kavajian?
Correct.
And Ms. Hernandez?
Correct.
Other than what was put on the record. Okay. So if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, ma'am?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
Do you understand that if the plea is accepted and you engage in any misconduct defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the term of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentencing. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Ma'am, do you have any questions about the rights that I've given to you?
No, I do not.
All right, so how do you wish to plead to the charge that on or about July 7 of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense listed under count 2, third-degree arson? Guilty or not guilty?
Guilty.
Okay, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea agreement to induce, or the plea bargain to induce the defendant to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Kavajian?
None, Judge.
All right, so other than the plea agreement that was placed on the record, ma'am, has your attorney promised you any other particular sentence or estimated what your sentence will be in terms of probation, fines and costs, incarceration?
No.
All right, is it your own choice to plead guilty?
Yes, it is.
All right, so ma'am, on July 7 of 2024, we're in the city of Adrian in the county of Lenawee.
Yes.
And so Mr. Kavajian, if you wish to voir dire, I don't know if it was started a fire or an explosive device, perhaps you can ask her the questions for what happened that day.
Sure, Judge. On the date in question, were you using any fireworks?
Yes, I was.
And did one of the fireworks that you ignited land on the victim's property?
Yes.
And did it ignite a fire?
Yes.
Judge, is the court satisfied?
Mr. Hartung might have a few questions about intent.
Counsel, also, okay, may I ask a couple questions? Fine, is that all right?
Absolutely.
Okay. Mr. Hernandez, the property that was ultimately burned by your throwing of a, was it, you threw a firework onto this property? Is that fair to say it that way?
Yes.
And do you remember what type of firework it was?
I don't.
The police report indicated that it was a red rhino, colorful dream fountain type of firework. Does that ring a bell with you?
I honestly don't remember because I was intoxicated at the time.
Okay. You were told later by the police that your fingerprints did appear on the paperwork for that firework that was thrown. You understand
Yes.
that?
Yes, 7
Okay.
months later.
Correct. And the person who whose house was damaged, you did not know the individual who owned that house. Is that correct?
No, I did.
No, I'm not talking about the tenant. I'm talking about the owner of the house. Did you know the owner?
Of the house?
Yes.
Yeah. Yes, I did.
How did you know the owner?
We used to be in a relationship together.
Okay, that would have been one of the tenants of the house, correct? One of the
So
people.
ma'am, do you understand that was a rental property and there's an owner and then the person who was renting?
Okay, then no, I do not. Sorry.
Okay, thank you.
You did not know the owner, but you did know some people that were living inside the property, correct?
Correct.
And one of those was a person you had a previous romantic relationship with.
Correct.
And where were you at in relation to the entryway of that property when you threw the firework?
On the stairs.
Okay, was it your intention to throw the firework inside the property?
Yes.
And you understand that when you did this, the firework, you had lit the firework before you threw it, is that correct?
Yes.
And the firework ignited inside the entryway or foyer to the house, causing some damage to the carpet and rugs and footwear that was in that area. You understand that?
Yes.
I have no further questions. Thank you.
All right, thank you. Has court complied with MCR 6.302 B, C, and D? Mr. Hartung?
I believe it has, Your Honor.
Mr. Kavajian?
Absolutely, Judge.
All right, accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. There is a Killebrew agreement between the prosecutor's office and defense counsel, and the court will, of course, as long as there's no violations, honor that plea agreement or Killebrew agreement. But other than that, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I will address bond just in one moment. I'm going to refer the matter to the probation department for a pre-sentence investigation. Mr. Kavajian, are you available September 5 at 8:15? Well, first I need to ask, Mr. Hartung, do you wish sentencing to be in person or via Zoom?
It can be by Zoom.
It can be by Zoom. So Mr. Kavajian, Ms. Hernandez, you have a right to come in person and stand in the courtroom, right? But you can also appear via Zoom. So I'm going to leave that choice up to you. Do you want to appear in person or via Zoom?
Zoom would be better. That way I don't have to miss work.
Okay. So Mr. Kavajian, that being said, are you available September 5 at 8:15 in the morning?
Absolutely, Judge.
All right. So I'm going to set this for September 5 at 8:15 in the morning via Zoom. So ma'am, when we're done here in a minute, I'm going to put you in a breakout room with the Michigan Department of Corrections Probation Department. Your attorney can go to. And when you speak with them, they're going to give you some instructions, a packet to fill out, instructions, as well as a time to come meet with them. When you do meet with them, be truthful with them about your background and the events that occurred. They'll prepare a pre-sentence report. We will get that to your attorney. Your attorney will review that with you before the day of sentencing, and then we will see you back on that day Mr. Kavajian, do you wish to address bond now?
I would, Judge, please.
Go ahead.
As the probation department already notified you, she's been in compliance with everything that's been required of her, in compliance with the tethered requirements. She is a single mom, Judge. She is working at Motel 6. Her child does have some medical issues for which she is requesting permission to travel. I believe it's to the state of Ohio. And then she does also have travel request due to her employment that I believe she needs to go to the state of Texas. So we were hoping that the court would allow her for permission to travel while on bond, and later, as long as everything's good on bond, extend that throughout probation if she needs to travel for medical or employment. And we would also ask Judge if the court would allow her to remove the tether. It is rather pricey for a single mom, and she has been in full compliance, and she wants nothing to do with her ex. She's not seeking any contact with him. So I kind of don't really see the need for it. I could definitely see the need for it when we first started this case, but where we're at now, her need to move on, her desire to move on, her want to never see this man ever again, coupled with the fact that she's got a lot to lose here. You're gracious enough to give her that HIDA deal. If she were to violate bond, she understands that HIDA is not going to be in her future. And I think that carries, a big carrot with it. And with that carrot, with that benefit, I think we could maybe, lessen the leash a little bit and understand that she's not going to be going near this guy because she's so desiring of that HIDA deal that I think we can just trust that she's going to be okay and follow all court orders without having a device on her ankle.
So for traveling for work, is she moving there or is she just going and coming back?
I believe it's just temporary. Is that correct, Ms. Hernandez?
Yeah, just going and coming back.
Mr. Hartung, your position, please.
Mayor, I don't have an objection to either one of the requests. I would indicate to the court that Ms. Hernandez has shown up for court every single time before myself and her attorney is.
Okay. And she was here bright and early this morning. All right, so I will remove the tether. So ma'am, we'll do the order today and you'll need to go to the company that installed it, get that removed. We will change her bond to allow her to travel to Ohio and Texas. Hold on, I gotta make good notes. And you probably need to call Mr. Coast, Ms. Hernandez, and let him know so he can make arrangements and tell you what to do on the tether. Mr. Kavajian, do you wish to go in the breakout room with her in the Michigan Department of Corrections?
I'm happy to do so, sure.
Okay, so I'm gonna put you in that breakout room with Mr. Jones and we will see you back then on September 5 at 8:15 in the morning. Go ahead and join that breakout room. Thank you.
Thank you so much, Judge.
Thank you. Thanks, Mr. Hartung.
Yeah.
So is that thing? Hey, this is Judge Anslone. I am ready first for Rodriguez Lofton and then.
Rodriguez Lofton.
Yep, and then after him, I can take Lewis Adams because I should have his attorney by then.
Okay.
All right, thank you.
All right, bye.
Bye. All right, so let me see here, Mr. Barker, I see you, but I got a couple people in front of you. So Mr. Malaro, let's see what I got. Bridget Reinhardt here. So in the matter of the people of the state of Michigan versus Bridget Susan Reinhardt, file number 21-20279FH. This is the date and time set for a pretrial on a probation violation. Looks like there's a Bob. Mr. McCarron sent an email, said she's really paid well lately. I'm good with dismissal. So I guess we'll just dismiss the Bob on that one, all right?
Okay, Judge, thank you. I'll let her know.
Okay, thank you. So, okay, then Roy Moore. Is there a Roy Moore in the courtroom? Roy Moore? All right. Do you have Roy Moore, Mr. Malaro?
I do not, Your Honor.
The call cannot be completed if the call cannot be. I got Harold Morris, Osborne, Walworth. I don't have a more either. Becky, oh, it's a waiver of arraignment. I'm sorry. Okay, so then that's Mr. Fry. All right, Mr. Malaro, we're waiting on Lofton. I believe Lofton is the last one you have with me. So we'll wait for Mr. Lofton. Let's see who else I got attorney wise. Okay, so next attorney I let in was Ramsayer. Go to him.
And I had Harlow, Your Honor. I believe he's in your waiting room.
Harlow, you mean? Andrea Harlow?
Yes, it's Burton he's using his wife's stuff. As he's not allowed to have electronics, so.
Okay.
And this is with Miss R.
Yep, okay. Let me see.
Oh,
All right, so Mr. Harlow, go ahead and unmute your device for me, all right? I just sent your request to unmute your device. There you go. This is in the matter of the people of the state of Michigan versus Burton James Harlow, file number 25-22276FH. This is the date and time set for a pretrial conference in this matter. I have Ryan Ramsayer appearing on behalf of Mr. Harlow, and I'm guessing Allison Arnold appearing on behalf of the people. So, as I said, this is the date and time set for a pretrial. So, Mr. Ramsayer, how do you wish to proceed today?
Your Honor, I've been in discussions with Miss Arnold. We're working on a resolution at this point and believe we may have one. We're asking for an adjournment of this pretrial. I did speak with Miss Arnold about her calendar coming up in August being quite full, and we're hopeful that we could have a pretrial date sometime in September.
September 10 at 8:30 in the morning, would that work?
If I may check, yeah, is that by Zoom, Your Honor?
Yes, sir.
That would be fine, Your Honor. Thank you.
All right, Ms. Arnold, is that all right?
It's great. Thank you.
All right, so Mr. Harlow, I'm going to set this for a pretrial on September 10 at 8:30 in the morning. Same Zoom number. Mr. Ramsayer, can you do a stip in order to adjourn?
I can, Your Honor, and I'll have that
And
sent.
Miss Arnold, can he sign your name with permission?
You can. Thank you.
Thank you very much.
I'll have the right over.
All right, thank you, Mr. Harlow. You are all set.
Thank you, Your Honor.
Hold on 1 second. Mr. Barker. Oh. Where's he at? Oh, there he is, Steve Barker. Okay. I just let. Yep. All right, so Kara Barker, Yellett, is it Yellett or Yellow? Oh, she's not connected to audio. So
Yellett.
she needs Yellett. Okay, thank you.
Yes,
Where are
please, thank you.
Okay, good. So it's Yellett. All right, this is in the matter of the people of the state of Michigan versus Kara Christine Barker Yellett, file number 25-22270FH. I have attorney Steve Barker appearing on behalf of Ms. Barker Yellett, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial conference. So, Mr. Barker, how would you like to proceed today?
Well, Your Honor, we had a meeting approximately 3-4 weeks ago with the officer in charge of the case. That was suggested by Phoebe, and with the idea that he would meet with my client and find out what she's doing in terms of trying to remedy the situation. I haven't heard anything from back from the prosecutor's office since that point. She continues to return merchandise to people who have requested the return of the merchandise. What she does, Your Honor, she customizes horse models, and some of the people have
Okay.
asked for the return of their things, and so she's
So are
returning
you
them.
asking for another pretrial?
Yeah,
or-
I guess we need another pretrial, Your Honor. We're trying to work out some kind of a resolution. It's
Excellent.
a case that very likely should be a civil case, but at this point, we're trying to
Okay.
see if we can't make everybody happy.
Would September 10 at 8:30 in the morning work?
The court's indulgence for just one moment, Your Honor.
And that would be Zoom.
Grab my book here. I'm sure that probably is fine, but give me just a moment. By the way, I have to compliment the court on how efficiently you're running the courtroom on Zoom. I get to see a lot of judges. You're doing a great job.
Thank you.
September 10th would be fine, Your Honor. What time?
8:30 in the morning. So I'll set a pretrial for September 10 at 8:30 in the morning. Ms. Yella, it's the same Zoom number as we used today. And Mr. Barker, our procedure typically, you will do a stip-in order to adjourn the date from today to that day. Mr. Bayonetto, can he sign your name with permission?
He can, thank you.
All right.
Could I have Your Honor, if I could have a spelling on the name, please?
I'm sorry.
On counsel's name, I need a spelling.
Oh, Alexander, Alexander. And then nice Italian downriver name, Bayonetto, Bayoneto.
Bayonetto, okay. Okay, very good. I grew up in a Sicilian neighborhood, but that's a new one to me.
Thank you. All right, you have a good day. Thank you. Thank you, Ms.
Your
Barker
Honor.
Yellett.
Thank you.
Okay. All right, so who has a case in the courtroom that I haven't called yet? You do, what's your name?
Frank Bowers. Osborne, Jerome Osborne.
Okay, all right, so my next, Mr. Fry, can I take care of Michelle Harding? She's been here since 8, okay. And then Mr. Dagmar goes in, I'll take your guy next, okay? All right, Ms. Harding, go ahead and start your video. Excellent. So this is in the matter of the people of the state of Michigan versus Michelle Lynn Harding. 2 files, 24-21779FH, 24-21780FH. This is the date and time set for pretrial. I have Brian Fry appearing on behalf of Ms. Harding, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial conference. Mr. Fry, how would you like to proceed today?
So, Your Honor, in this case, yesterday evening, I think we actually worked out a resolution. My client is in Sault Ste. Marie, so I wasn't able to get her to sign the advice of rights yet. So I don't know if the court's going to proceed or not on that, but
if you can just mail it to her in a self-addressed stamped envelope and get it back before sentencing, that would be fine.
perfect. So my client, Your Honor, would on file 2421780FH. She'd be pleading to count 2, count 3, and count 11. No habituals. The other counts would be dismissed. And then on file 2421779FH, it would be dismissed, but she would admit for restitution purposes only. And I would note that it's not part of the plea agreement or anything, but she has been accepted into the recovery court program.
Okay, excellent. You write that down. Is that a correct recitation of the plea, Mr. Bayonetto?
It is, Your Honor.
All right, so Ms. Harding, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name for the record, please?
Michelle Lynn Harding.
All right, so Ms. Harding, you have heard the plea agreement that was placed on the record. by the prosecutor's office, and, well, your defense counsel, and concurred with by the prosecutor's office. So is it your intention to plead guilty to, let me make sure I get this right, count 2, conspiracy to commit financial transaction device illegal sale or use, which carries a maximum penalty of up to 4 years in prison and up to $15,000 in fines. Count 3, conspiracy to commit financial transaction device illegal sale or use, which again carries a maximum penalty of up to 4 years in prison and possibly up to a $15,000 fine, as well as count 11, conspiracy to commit computers, using a computer to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years and up to, well, it says 7 years and or a $5,000 or $10,000 up to $15,000 fine. So is it your intention to plead guilty to those 3 counts?
Yes, Your Honor.
All right. Are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Yes, I am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Fry?
That's correct, Your Honor.
Mr. Bayonetto?
That's correct, Your Honor.
And Ms. Harding, is that correct as far as you're aware?
Yes, Your Honor.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have, wait a second, you said she lives in Sault Ste. Marie?
She's in transitional house.
Oh, she's coming back though. Okay, I was like, wait, I can't do recovery court with her. All right, so you have a right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Ms. Harding?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. Do you understand all of that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so we're going to go through each count. So, ma'am, how do you plead to the charge? How do you wish to plead to the charge that on or about the time period of March 25 of 2023 through March 28 of 2023 in the city of Tecumseh in the county of Lenawee, that you did commit the offense listed under count 2, conspiracy to commit financial transaction device illegal sale or use? Guilty or not guilty?
Guilty.
All right, and under count 3, conspiracy to commit financial transaction device illegal sale or use? Guilty or not guilty?
Guilty.
And under count 11, conspiracy to commit conspiracy to commit computers, it just never makes sense, using to commit a crime, maximum imprisonment of 4 years or more, but less than 10. Guilty or not guilty?
Guilty.
Okay, Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, Your Honor.
Do you understand if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fry?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Has your attorney promised you any other particular sentence or estimated what your sentence will be other than what was placed on the record, ma'am?
No, Your Honor.
Okay, is it your own choice to plead guilty?
Yes.
All right, so Ms. Harding, from March 25 of 23 through March 28 of 2023, were you in the city of Tecumseh in the county of Lenawee?
Yes, Your Honor.
All right, so along with some other people, did you use a financial transaction device? All right, I don't know the facts of this, so you want to help me out, Mr. Fry? It's pretty bland.
Yeah. So, Michelle, during that time period, were you involved in a Speedway gift card scheme?
Yes.
Okay, what were you doing with the Speedway gift cards?
I was selling them, getting stuff for people, and I would sell it so I get money for drugs, and I was homeless and for gas in my car. I was living out of my car at the time.
Okay. Did you work at Speedway?
No.
Were you, how were you obtaining those Speedway gift cards?
My sister stole them, and
Okay. And you knew that that was the case, right?
yeah, yes,
And then you were selling those gift cards for money and services?
yes, for drugs and somewhere to sleep and food and.
You did that at least twice, correct?
Yes, Your Honor.
Okay.
I think there was.
I need 11, count 11, the computer.
Multiple instances of you using those credit cards or gift cards?
Yes.
Okay. And then was a use of a computer involved in furthering your
my phone.
gift card?
My
Okay.
phone.
So it was your phone?
Yes.
Okay. How are you using your phone in furtherance of this gift card scheme?
The cards were downloaded on my phone. They got downloaded on my phone.
So they were e-gift cards then?
Pardon me?
They were e-gift cards, electronic gift cards?
What do you mean? Like, what do you mean that you give? There's like Speedway cards.
Yeah, and you had them saved on your phone?
Yes, on one of my
Then
old
were you-
phones, yeah.
Were you transferring them from your phone to somewhere else then?
No,
Okay, what were you doing with them on your phone?
I would just have them on the Speedway app. They were on a Speedway app and they downloaded them on there and used my phone. They scanned my phone to
Oh,
to,
so they're
use them.
being scanned. You use your phone to
From
scan
Speedway.
the gift
Yes.
to get the money off of the gift cards?
Yeah, I'd buy stuff for people and they would give me money so I could get drugs and gas and food and somewhere to sleep sometimes.
Okay. And would you agree that the illegal use of the financial transaction device charges that you're charged with carry a 4-year sentence max?
Yes, I do.
I don't think I have anything further here.
Are you satisfied on those 3 counts, Mr. Bayonetto?
Yes, Your Honor.
Right, and what is the restitution on the other file? Is that a set amount or is it unknown at this point?
It's $100, I think, Your Honor.
And then the restitution on this file is to be determined?
Yes, Your Honor.
Okay, make that in, to determine, and then restitution to, okay. All right, has court complied with MCR 6.302 B, C, and D? Mr. Fry?
Yes, Your Honor.
Mr. Bayonetto?
It has, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. her rights, I'm sorry, she does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. So Ms. Harding, you've already been screened for recovery court. They've been in contact with you. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Fry, I am setting sentencings for, let me find the date here, September 5 at 8:15. Are you available that day?
Yes, Your Honor.
All right. So Ms. Harding, you should be done with your treatment by then?
Yes.
All right, and then you'll be back in town, right?
Yes.
Okay, good. So do you want that to be in person or via Zoom, Mr. or Ms. Harding?
It can be in person, I assume. I mean,
okay.
I should be down there by then, so.
Okay, I'll put in person. Mr. Fry never leaves here anyway. He's always somewhere in this building. So, Mr. Jones, do you want a breakout room or has there already been contact with Mr. Moore and Ms. Teskey?
I am not aware of any contact, so I better just have a short breakout just to make sure.
All right, so Ms. Harding, I'm gonna pop you in a breakout room with Chris Jones. He is from the Michigan Department of Corrections. He's gonna give you some instructions on what you're gonna need to do. Obviously, you're in a treatment facility. When's your out date there?
It's traditional, so I've been here for a while. So whenever I wanna leave, you know, I've already went to rehab. I went to sober living afterwards.
All right, so I'm gonna set it for September 5. Obviously, Mr. Moore wants to move it, Mr. Jones, that's fine. So when you go into the breakout room with Mr. Jones, he's gonna give you instructions. You're gonna have to meet with the probation department, fill out a packet. Be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Mr. Fry. Mr. Fry will get a hold of you and review that with you before the day of sentencing, and we'll see you back on that day. Mr. Fry at some point will get an advice of rights that we need signed. It's just basically a written version of what I said on the record today, but we'll need a signed copy back for the file, okay?
Okay.
And I'm still getting used to that because the law just changed and I just realized I didn't do it for 3 people this morning. But so, all right, Ms. Harding, go ahead and join that breakout room.
Thank you, Your Honor.
Doug, you're supposed to remind me. I'm blaming this on Doug. All right. All right, so go ahead and join that. Okay, so next, Mr. Malaro, we have Mr. Lofton. Let me get Mr. Lofton here.
I'd like to speak with our attorney too before we proceed.
Yeah, hold on, let me call the case first. So this is in the matter of the people of the state of Michigan versus Rodriguez Lofton, file number 21-20524FH, 23-21207FH, and 24-21769FH. I have Salvatore Malaro appearing on behalf of Mr. Lofton. I have Alexander Bandetto appearing on behalf of the people. This is the date and time set for pretrial. Mr. Malaro, would you like to break out room with Mr. Lofton?
Since he requested it, I suppose so.
Okay, so Mr. Malaro, I'm going to assign you and Mr. Lofton to a breakout room. So Mr. Lofton, you go right ahead and join that breakout room with your attorney, Mr. Dagger-Margosian. We have Mr. Osborne.
Yep.
Okay, so, all right, make sure you got that microphone. So this is in the matter of the people of the state of Michigan versus Jerome Trask Osborne IV. File number 25-22266FH. Mr. Dagger-Margosian, thank you so much. There is an advice of rights in the form. And I have Alexander Bandetto appearing on behalf of the people. This is the date and time for a pretrial conference. So, Mr. Dagger-Margosian, how would you like to proceed?
Your Honor, I've reached a resolution with people. I've been speaking with this about this case with Ms. McClure. At this time, we are ready to enter a plea. Mr. Osborne will be pleading guilty to fleeing and eluding fourth degree, as well as operating while visibly impaired second offense.
Miss Mindy, are you picking Mr. Dagger Margosian up?
Yes, Judge, thank you.
Okay, all right, so he's gonna plead to count, which one?
Well, if the people, I don't know if the people submitted an amended information, but it's fleeing and eluding fourth, OWVI second offense.
Miss Adams, did you give me an amended information for Osborne this morning?
I did not, Judge.
So I don't, okay, so I do not have an amended information. Mr. Bayonetto, would you be able to get that to me today?
I can, Your Honor, yes.
Okay, so I'm sorry, Mr. Dagger Margosian, because I was looking, so it's gonna be an added count 3.
Added count 3 of fleeing and eluding fourth degree.
That's a 2-year, right? And count 1 and 2, as well as the habitual offender notice will be dismissed.
Correct, but it would also be a guilty plea to, I guess, another added count of OWVI second offense.
Okay. So account 4 what?
Operating while visibly impaired.
Which is then 93 days?
Well, it would be, but second makes it a 1 year.
Okay.
Yeah.
Operating while visibly impaired, second offense, which is a 1 year. Is that a correct recitation of the plea, Mr. Bayonetto?
It is, Your Honor.
And you'll get me an amended information today, right?
Yes, Your Honor.
Otherwise, they yell at me for taking these pleas. Okay, so can you stand at the podium? Yeah. It's just the audio is better there. And okay, so Mr. Osborne, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, and you can, yep, make sure you kind of stand near that microphone. So, Mr. Osborne, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count 3 fleeing and eluding fourth degree, which carries a maximum penalty of up to 2 years in prison? I believe there is a mandatory license suspension, and there's some points, I don't know what they are, and fines of up to like $2,500. Do you understand that?
Yes, Your Honor.
Is it your intention to plead guilty to that count?
Yes.
And then is it your intention to plead guilty to an added count 4 operating while intoxicated second offense, which carries a maximum penalty of up to 1 year in jail?
Yes, Your Honor.
And there's probably community service and some fines and costs and some points and I think another license suspension. Do you understand that?
Yes, Your Honor.
So you understand you're not gonna have a driver's license for a while? Verbalize.
Yes, Your Honor.
Okay, all right. So are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he's given you?
I am.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Dagger Margosian?
Correct.
Is that correct, Mr. Bayonetto?
Correct, Your Honor.
Is that correct as far as you know, Mr. Osborne?
Yes, Your Honor.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable, the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. So do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal that from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by your plea. So misconduct is defined to include, but is not limited to absconding, failing to appear for sentencing, violating terms of condition on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. Do you understand that?
Yes, Your Honor.
And if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. How do you wish to plead to the charge that on or about March 20th of 2025 in Deerfield Village in the county of Lenawee, that you did commit the offense under count 3, fleeing and eluding 4th degree, guilty or not guilty?
Guilty.
And how do you plead to the charge listed under count 4 that you committed the offense of operating while intoxicated, 2nd offense, guilty or not
Your
guilty?
Honor, I'm sorry, visibly impaired. I'm sorry.
Operating while visibly impaired. What is like?
It's just for a second.
I'm not a district court judge, so what would my notes say? Operating while, because I have to give notes to Miss Spade.
Yeah.
Operating while visibly impaired.
And the only reason I bring that up is obviously it really wouldn't have an effect on the court, but for Secretary of State.
No, I know, OWI and then impaired. Yep. Okay, I got it. I just made my notes better for Miss Spade.
Thank you.
How do you wish to plead to that charge?
Guilty as well.
Okay. All right. All right. Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Hold on. I got Mr. Murphy. Hold on. Mr. Murphy's like sending chats and squirreling me and distracted me. So is that correct, Mr. Dagger-Margosian?
Correct, Your Honor.
And Mr. Murphy or Mr. Bandetto?
Correct, Your Honor.
All right. Has your attorney promised you any particular sentence or estimate what your sentence will be, Mr. Osborne?
No, Your Honor.
Okay. Is it your own choice to plead guilty?
Yes, Your Honor.
Okay. So, Mr. Osborne, on March 20th of 2025, were you in Deerfield Village in the county of Lenawee?
Yes.
All right. Was he impaired by alcohol or?
It was alcohol. It was under the legal limit, but it did, for practical purposes, it did affect the ability to drive.
All right. So, had you consumed alcohol that night?
Yes.
What did you drink?
I had a double Jack and Coke.
A double Jack and Coke? What else?
That was it.
That was it? And then you got in your car, right? You gotta speak to me.
I did.
Okay. And would you say that that drink and was in your system at that time and impaired your ability to drive and make good decisions?
Yes, Your Honor.
Okay. And so at some point, a deputy Howard with the Lenawee County Sheriff's Department was driving his car and came upon you. Is that correct?
Yes, Your Honor.
And then he turned his little lights on. And when those lights went on, you knew it was a police vehicle.
Yes, Your Honor.
And you knew he was pulling you over.
Yes.
And you didn't pull over right away, did you?
I did not.
You kept driving?
I did.
Okay. And did you go over the speed limit of 35 miles per hour, which was posted in that area?
I'm not too sure about that. I was following most of the speed limits everywhere in town there. I wasn't like a high speed chase.
How long did you drive? 5 minutes?
Yeah, just went around a big country block pretty much.
But you didn't pull over?
No.
Okay.
I mean, eventually I did, yes.
All right. Okay, so I guess I misspoke. So would you agree the speed limit was 35 miles per hour in the area that you fled from the police?
Yes, Your Honor.
Okay. Are you satisfied? Did I cover everything, Mr. Dagger-Margosian?
Yeah, I think the only thing I would add is.
Oh, I got to do the sub. All right. So, Mr. Osborne, you were previously convicted of operating while intoxicated on November 2nd of 2015 in the Mentor Municipal Court. Where is that at?
Ohio.
Northeast Ohio.
Northeast Ohio. All right. So you have a prior conviction for operating while intoxicated. Is that correct?
I do.
Okay.
Yes.
Are you satisfied now, Mr. Dagmar goes in? Mr. Bandetto, are the people satisfied?
Yes, Your Honor. I'm just for the record, I'm sending that amended information over right now.
Okay, just follow it with the clerk's office. I think they want, accept the plea. It has been, given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. The date we're using, Mr. Dagmar Margosian, is September 5 at 8:15. Are you available that day?
September 5 is, it's my dog's birthday, but other than that, I'm here, Judge.
Are you sure?
Yeah.
You can take that day off.
No, I'm just kidding.
I mean,
Yeah,
as a
yeah.
good pet owner, you would take the day off.
I try. No, I'm, thank you.
Okay. All right. Do you want to appear via Zoom or in person?
Either or.
Okay, so we'll put in person, and then, all right, so Mr. Osborne, I'm gonna send you across the hall to the probation department. When you go over there, just check in. They're gonna give you a packet to fill out and some instructions on, setting up a meeting with them. When you meet with them, be truthful about your background, be truthful with them about the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Mr. Dagmar Margosian. He will review, he always does review it with you before the day of sentencing. And then we will see you back on September 5 at 8:15. Miss Adams, could I possibly get a notice of hearing for Mr. Osborne?
Yes, and I'm so sorry. Did he say in person or Zoom? I missed it.
Yes, in person.
In person, thank you.
Yep, so have a seat right behind you on that bench behind you. Yep, and we will get you a notice of hearing. All right, Mr. Osborne?
Okay, thank you.
All right, and then when you're done with that, you just step right across the hall and check in at probation.
Okay.
All right, Mr. Dagmar Margosian, does that conclude my docket with you?
I'm all set, thank you.
All right, thank you. All right, so Mr. Where'd you go? Hold on. Isn't, let me call for Adams. I should have her. I know she's been waiting for Adams. Hey, this is Judge James Sloan. How you doing again?
All right.
I am ready for Lewis Adams.
You ready for Adam?
Yes.
All right, we'll set him up.
All right, thank you. Bye. Okay, so Mr. Malaro, where'd Mr. Malaro go? All right, Mr. Lofton, you just hang tight for a minute. I lost Mr. Malaro, but he'll be right back. All right. Okay, so we're waiting on Adams. Mr. Glazier.
Yes, Your Honor.
All right, I am going to call, maybe I'm not. I got Adams, Avila, Powers, Ford, Candace, Morris, Walworth. Miss Adams, do we still have Tomas Avila today? I don't have a file for it. Okay, I'm gonna call it though. So in the matter of the people of the state of Michigan versus Tomas Angel Avila, file number 25-22279FH. I have John Glazier appearing on behalf of the defendant and Alexander Bandetto appearing on behalf of the people. I don't have a file. I probably did something with, oh, wait, I found it. It was there. All right, so Mr. Glazier, this is the date and time set for pretrial. How would you like to proceed? He is not here. I did give him personal notice.
He's here.
Oh, there he is. Hi, Mr. Avila. All right, so how would you like to proceed today with him?
Your Honor, it was indicated to me that he could plead to an attempted
Possession of meth with a 1-year delayed sentence.
What? He's charged with CCW.
Oh, excuse me, I'm reading the wrong file. Sorry about that. Yeah, he's going to plead to attempted CCW with a 1-year delayed sentence.
All right, an attempted CCW with a delayed, that would be a 2.5-year with the delayed. You said delayed or deferred?
Delayed for 1 year is what I was told. I don't have a reduction form though.
I don't have that in the file. I'm not sure. The only thing I have is attempted with no jail. I'm not sure.
Okay.
Mr. Sneed's
So
notes indicated the case was going to be adjourned, so I don't know.
So Mr. Glazier, Mr. Sneed is not available today, and I believe he is your prosecutor. Would it be possible to set this out to like August 13 or next week? And that way I can get a plea reduction form.
Yeah, that's fine, Your Honor.
And then do you have a copy of the advice or rights for your client, Mr. Glazier?
No, I don't.
Okay, Ms. Adams, could we email to Sarah or Leo the advice or rights forms? And while Mr. Tomas is there, maybe, or I mean, Mr. Avila is there, he could sign it. All right, so is next week okay, Mr. Glazier?
That's fine, Your Honor.
All right, so
Your Honor, Mr.
Mr.
Sneed doesn't come back until I believe July 31st is his first day back.
All right, let's do August 13, Mr. Glazier. I'm going to adjourn it to August 13 at 8:50.
Could you hold on a second, Your Honor?
Yeah.
Yeah, that's fine, Your Honor.
All right, so we'll set it over to August 13 at 8:30 in the morning. Mr. Glazier, Ms. Adams will make sure you get a copy of the advice of rights form. You should probably have a stack of them for your clients to sign because we need those. And then we'll get a plea agreement form at that time, okay?
That's fine, Your Honor.
And you'll do the stip in order to adjourn. Mr. Bandetto, can you sign your name with permission?
You can, yes.
All right, delayed 1 year. Okay. And I think no upfront jail was part of it. Okay, you said no upfront jail was in the notes, Mr. Bandetto?
Yes, Your Honor.
All right, awesome. Thank you.
All right.
Okay. Mr. Bowers, you want to come on up? Mr. Glazier, I have Mr. Bowers here. All right, this is in the matter of the people of the state of Michigan versus Gregory Allen Bowers. We're gonna need that advice rights form for him because I forgot it before. So Mr. Bowers, we're gonna hand down to you advice of rights form. It goes through what I'm gonna read to you on the record. And then I'll just need you to sign it and we'll need a copy of that back, all right?
Yeah.
I have John Glazier appearing on behalf of Mr. Bowers, and I have Dan Gumtoe appearing on behalf of the people. So Mr. Gumtoe, this is your file?
Yes, Your Honor.
Okay, perfect. So this is the date and time set for pretrial. I have a plea agreement form in the file that said Mr. Bowers will plead to possession of cocaine, which is and count. Okay, so Mr. Gumtoe, if you could take a look at the amended felony information.
Yes, Your Honor.
It has count 1, possession of methamphetamine, count 4, habitual offender fourth in that offense, and count 2, possession of cocaine. So if you could kind of fix that.
Your
Yes,
Honor.
Your Honor.
I just
Yeah.
got that. I just got that reduction form sent to me. I had a chance to discuss it with Mr. Bowers. Just came in.
Okay.
yesterday.
Do you want to go talk to him?
Sure.
Okay, so my bailiff's gonna take you out in the hallway and there's there's a device out there. He's gonna log you in, and then you can take a chance on Mr. Glazier. I mean, take a moment to speak with Mr. Glazier. And then when you're done, you can just come back in here, okay? Don't worry about shutting it down. Okay. All right, Mr. Lofton, I'm sorry, we have a trial next door, so I'm sure that Mr. Malaro had to run back down there. So hold on a second. Did you guys settle my afternoon hearing, Mr. Fry? No. You're supposed to bully Adrian Iddings and you guys fight it out and settle it. So I wouldn't bully her. She's a little scary. All right. Hold on, Rhonda. I'll be right with you.
Thank you.
Okay. Rhonda, what are you here for?
I have Jason Crone and Joshua DeMullen.
Yeah, nobody showed up. I issued bench warrants for him. Not working? No. All right, hold on. I'm gonna go out, see what's going on.
Keep buffering, then we'll come back to sign it.
I'll be right back. Something. John, I'm just sending him over. So he's just gonna walk over. You're at the office, right?
Yes, I am.
Okay, so he's gonna walk over.
All right.
Okay, so. All right, so Ms. Underwood, I'm done with you, but you're more than welcome to hang out.
I was wondering if you had already put those on the record, Your Honor. That was my only question.
A long time ago. Thank you.
Thank you.
Okay, so. Mr. Adams?
Yes.
Okay, so let me grab all your files. So, again, Mr. Lofton, your mom is here, as always, very patiently, putting up with me. So this is in the matter, right, of Louis Alfred Adams Jr., File number 24-21947FH, 24-21948FH, 24-21949FH, 24-22011FH, and 24-22012FH. I have Allison Arnold appearing on behalf of the people, and I have Brian Fry appearing on behalf of Mr. Adams. This is the date and time set for a pretrial conference in this matter. Mr. Fry, how do you wish to proceed today?
Yes, Your Honor, we had adjourned it out to today because we're waiting on a criminal responsibility report from the forensic center. They had indicated that it would be done by today, but it's not. I think Ms. Arnold got an update yesterday that they are now saying that they will have it by the end of the month. So we'd be asking for an adjournment into August sometime.
August 13 at 8:30 in the morning.
That works for me.
All right. So Mr. Adams, I'm going to set it over to August 13 at 8:30 in the morning. Hopefully we have that back by then. We should. Those usually come in pretty timely compared to competency. So we'll see you back on that day. And Mr. Fry, you get to do the step in order for all those files. And Ms. Arnold, can he sign your name with permission?
He certainly can, Judge.
Okay. All right. Thank you very much. And again, your mom's always here. So thank you, ma'am.
Thank you.
You're welcome.
Thanks, Judge.
Sir, all set, Mr. Adams.
Yes, ma'am.
All right. Let's go through our docket. Mr. Bowers is on his way over to see Judge Olsaver or John Glazier. So, Miss Adam, on Horde, do we know if Lance Ford's going today? I don't have either Mr. Noy or Mr. Horde. Miss Adams, let me check with Mr. Noy.
I wasn't aware of an adjournment.
Huh?
I was not aware of an adjournment, but I'll check.
All right. All right, I sent that. Okay, we got Lofton. We're meeting on Mr. Malaro. And I've got Miss Dumont. No, I don't. She popped in, she popped out. I don't have Mr. Morris anyway.
Yeah, is Aaron Lambus trying to zoom in?
No.
Okay.
No, it's 11 o'clock.
It's at 11.
Oh, okay. Well, that would explain that.
Yep. So I really don't have a thing with you until 11.
Okay, I'll probably just hang out in case you come early.
Your Honor, if the court is comfortable, I think the plan on that case is to dismiss the felonies, and I think Mr. Murphy just needs to withdraw one of the motions he had filed if the court.
So hold on, let me call the case. In the matter of the people of the state of Michigan versus Aaron Wayne Lambus, file number 25-22159FH. I have Matt Murphy appearing on behalf of Mr. Lambus and Alexander Bayanetto appearing on behalf of the people. This is set at 11. We are on the record though. So Mr. Bayanetto and Mr. Murphy, do you need a breakout room?
No, Your Honor. I just wanted to place, first and foremost, there was a motion I filed to compel discovery. I wanted to withdraw that motion because Mr. Bayanetto was not aware that we had not received that. He timely got us that video that was in question of that motion. So again, I'm going to withdraw that motion to compel. But I believe Mr. Bayanetto, the other motion I had filed that was set for hearing, Mr. Bayanetto was going to dismiss the felony count in this case Now, I'll be honest with the court. I had thought that the law was added automatically or it had to be sent back down to district court when all felonies were taken off, but I think that's not correct. But either way, I think we'd ask for another adjournment for another pretrial because I believe that'll be a different prosecutor handling simply the misdemeanors. Either it's going to be here or in district court. So that was the intention today. Again, from my understanding, unless Mr. Bandetto had something other he was going to.
So are we canceling the 11 o'clock?
I would be fine with that, Your Honor, if the court is okay waiving Mr. Lambus's appearance. It is my intention to file dismissal on all of the felony R&O counts that would just leave the three remaining misdemeanors. If the court would be willing to remand that back to district court, I think that would be appropriate. I'm not sure
Did
what
that
the
law
procedure
go into
is.
effect yet?
That I'm not
there's
sure.
a proposed amendment. I mean, at this point, I don't know that I can remand misdemeanors, but I know there is a proposed change that they would be, but I don't think that's gone into effect yet. So wouldn't I take the misdemeanor plea and sentence them up here?
Well,
I'm not.
That was where I didn't know because we had in Judge Olsaver's court, we had voluntarily and Judge Olsaver ordered it to be remanded back down. So my understanding would be that if we agreed to it, that it could be nothing would preclude that. But again, my thought was I understood it, and I think I'm wrong that it was automatic. That's why I'm not sure.
So, hold on, everybody, stop talking. All right, I'm gonna double check, but I don't think that law passed yet. So give me a minute.
We'll grab those files.
Oh, you can grab all those. Take those, Miss Becky.
Sit tight. Yes, that's gonna call us up. No. Matter of fact, that actually kind of helps us.
You. I was like, I knew he's around here somewhere.
Yeah, well, I had some landlord tenant things at
It's okay.
9:30. So I ran as long as I could, came over here and took my car. Over.
Give me 1 minute. So Mr. Murphy and Mr. Banetto. So here's the deal. I think Judge Osava did at one time send it down, but district court's like, oh, we don't hear these. So there was a case that came down, which I thought maybe when I was on vacation, the law changed, but there was a case that came down that said if there's only misdemeanors remaining, they can be remanded down to district court, but Michigan has not updated the court rule on that. So if you dismiss all the felonies and there are misdemeanors remaining, I keep those and I monitor them on district court probation until such time as our Michigan court rule is updated. So
could we vacate the trial date because the trial set for July 22nd? And then again, I think there just needs to be some more negotiation in regards to the remaining misdemeanor counts. And then, again, I don't think we're gonna have a trial ultimately, but I'm not, right
So
now,
do
I
you want
wasn't
me to
sure
set- Yep, August 13 at 8:30, is that good?
if that works for people.
That works for me, Your Honor, and I will get that dismissal to the court today.
Okay, so, why would you do a dismissal? Wouldn't you just put on the record nully pros file 1 through 7 and plead to 8, 9, or whatever it is?
Well,
I can do it that way if you want, Your Honor.
Well,
I just
hold
with
on,
Mr.
hold on, everybody. So hold on. So my understanding, this is Lambus, right? So, all right, so what you're telling me, oh, so many motions, is that he has a 9-count felony information. The last three are misdemeanors. So is he pleading to like count 8 and 9 or something?
And that's the thing. I don't know, Your Honor. Mr. Murphy and I had kind of discussed it a little bit, but we don't really have
Okay,
any idea
so
where that
you
plea
don't
will go.
nully pro, like you'll do a nully pros, but I don't sign it until sentencing. So when you do the plea agreement form, it would be, he'll plead to count what and count what. And then the remaining counts will be nully prossed in any terms, but, so yeah, so I'll let you guys work that out. So, Mr. Murphy, just let Mr. Lambus know that his next pretrial will be August 13, 8:30 in the morning. And then you can do the stipend order to adjourn and then
Yes, Your Honor.
make sure he does. And Mr. Murphy, do you have the advice of rights forms that you've given to your clients?
Most people give me.
We have them. I know what form it is. I know I can fill it out and have my clients start getting it beforehand.
Okay.
That'll come
All
down
right,
and talk to
and
my
then-
office about that. So.
Yeah.
Yep, and then we'll see you back on, we did send them over to your support staff, so we'll see you back on August 13 at 8:30. We see Mr. Malaro bumping around there, let him know I got Mr. Lofton, but I think he got called somewhere else. All right,
Yes, Your Honor.
thank
Thank
you.
you.
I missed court up there because I got pulled up here.
Mr. Glazier, is your guy with you?
That's me.
Mr. Glazier, you still talking to your client?
I'm done, Your Honor.
Okay, so I'll call his file.
All right.
Okay, so this is back on the record in the matter of the people of the state of Michigan versus Gregory Bowers. So Mr. Glazier, if you need more time to talk to him this morning, that's fine. But, and he did sign the advice of rights form, which is awesome. And I do have a plea agreement form and an amended information. So thank you, Mr. Gumto and Mr. Glazier. So what would your client like to do, Mr. Glazier?
Your Honor, we'd like to adjourn this out. We need some more time to talk it over, but we also wanted to indicate that the amended information, and actually the original information says 4th offense felony. He doesn't have 4 felonies. I don't know why it says habitual 4th on it. And the other thing is that
it says, what does it say? Habitual offender, 4th offense notice?
Yes.
All right, so he only has 2 prior felonies, so you're saying it should be 3rd offense?
Yeah, they're only listing 1 in the notice.
So Mr. Gumto's got to amend that anyway, so he'll take a look at it again.
All right.
Okay.
Right.
So August.
The other thing, Your Honor, is if Mr. Gumtow said there'd be no upfront jail, that needs to be included in the plea agreement.
Okay, so Mr. Gumtow will update all of that. That's wonderful. So I'm going to set this out to August 13 at 8:30 in the morning. And obviously, Mr. Malao, if you work something out quicker and you want it brought in any other day than a Wednesday, that's great. And then Mr. Glazier, if you can do the stipend order to adjourn.
You called me Mr. Malaro.
I'm sorry, it's the beard. Mr. Glazier, August 13 at 8:30 in the morning.
All right, we got it. Thank you, Your Honor. That's all I have.
Okay. Mr. Gumtow, you can sign your name with permission.
Yes, Your Honor. Thank you.
Okay, thank you. All right. Let Mr. Malaro, because I need Mr. Malaro in my courtroom, so let him know I'm looking for him. Because I have Mr. Lofton.
He doesn't know what happened because.
All right, so Mr. Noe, who do you have with you?
Mr. Walworth and Mr. Ward, the co-defendants, both on our pleas.
Oh, they're both here. Okay. Okay. So we're gonna do one at a time, pick one.
Let's go with Mr. Walworth.
All right. We're gonna hand down, actually, you can bring them up and put them each at a table. How's that? And we're gonna give them an advice of rights form.
I submitted advice up to Ms. Adams
Perfect.
early this morning.
Awesome. Thank you for being prepared, Mr. Noe. Okay, so this is, who are you? Okay, so this is in the matter of the people of the state of Michigan versus Lance Aaron Horde, file number 25-22229FH. I have Charles Noe appearing on behalf of Mr. Horde, and I have Alexander Bayonetto appearing on behalf of the people. This is the date time set for pretrial. I'm going to assume your client's availing himself of the plea bargains.
They are.
What is the plea bargain for Mr. Horde?
On this matter, what it is my client will plead no contest as charged to the information. Upon completion of probation, that this matter will be reduced to misdemeanor larceny 200 to 1,000. There is also a killable agreement for no upfront jail.
What misdemeanor?
Larceny 200 to 1,000.
Okay.
That's upon completion of probation.
All right, hold on, let me get all that down. Okay, so, and the no upfront jail, you said?
Yes, it's a killable.
Okay, is that a correct recitation of the plea, Mr. Bayonetto?
It is, Your Honor. I believe Ms. McClure sent Mr. Noe a plea sheet. She did ask that I have him sign that and submit that to the court. I don't know if I heard anything about restitution. That is to be as determined by the court at the time of sentencing.
That's fine.
Okay, so let me put down running out of space.
Yeah, and restitution can be determined through the pre-sentence investigation. No problem with that.
Be determined. Okay. Okay, so
Mr. Noe, do you have a copy of the plea form with you? I can
do not.
bring it and bring it.
I didn't take. Do we have to use that? I don't really need to use that if we don't need to.
I don't need it right now, but
my marching order is to have it signed before the plea. So I'm gonna print that out and I'll bring them up right now, Judge.
Okay.
Judge, I don't know if it's the same, but I'm showing one scanned in from June 4th.
It's different. It's different. The previous one didn't have the killer brew and some other things on it too.
All right, so Mr. Bayonetto's on his way down, so we will give him just a minute.
Sure. Just has additional. Same.
Could you approach Mr. Noe?
Sure.
Which one is that?
Yes, that's right.
Yeah.
Down. Is it?
And she's living. They're nice people. And she said, "Mom." It's like when you turn on focus, the second one, right?
Yeah, that makes sense.
Uh-huh.
That makes sense. Marching orders and marching orders, yeah.
Sorry, I got a specific text from TV to make sure they were, so
Yeah, she's pretty hardcore about it.
just doing as I'm told.
The same as was last time. That's wrong way. Shit, I'm sorry. Right. Same thing, no incarceration. Just restitution. Okay.
Okay, while you guys are doing that, I got Mr. Malaro back, so let me take care of Mr. Lofton. All right. All right, Mr. Malaro, we're back on the record with Mr. Lofton. Mr. Bernardo, you're on Lofton, right? Okay, so Mr. Malaro, we did receive some communications regarding Mr. Lofton because we had set inquiries out regarding his treatment. So Mr. Lofton, or I'm sorry, Mr. Malaro, how do you wish to proceed today?
Well, Your Honor, by some miraculous intervention of a higher power, Mr. Lofton's been deemed competent to stand trial. So that's from a letter of June 24th, 2025 to Judge Olsager. I don't know how it went to him.
I don't, that's probably why I don't have it.
Said it is the opinion of this examiner that Mr. Lofton is no longer incompetent to stand trial. It is authored by Dana Korwak, certified forensic examiner. So now that he is competent, I would ask the court to adjourn this out to August
13?
6th, I think it is. He's got another, let me pull him up.
Yep. Okay, I can adjourn this for a pretrial on August 6th at
Okay.
8:30 in the morning, and you can do the stipend order to adjourn.
Yes, and the basis judge is he has a case in district court that's being heard on the 30th of July. So hopefully we can get a resolution at that point. And figure something out, I suppose.
All right, okay.
Also send that paperwork to me, Mr. Malaro, from the forensic psychologist.
I will have it sent over, Mr. Lofton.
Okay, thank you, sir.
Yep.
All right, Mr. Lofton, thank you for your patience this morning.
Yes, ma'am.
And I believe, Mr. Malaro, I have nothing further with you today.
All right, thank you, Your Honor. Have a good day.
Thank
All
you
right,
so much.
thank you. Okay, all right, so we are back with Mr. Noe, and I have received the plea agreement forms. They're done. Okay, so let me call the other case. So then we also have the matter of the people of the state of Michigan versus Corey Thomas Walworth, and that is file number 25-22228FH. And again, I have Charles Noe appearing on behalf of Mr. Walworth and Alexander Bayonetto appearing on behalf of the people. So I have received what appears to be identical plea offers on both of these cases. Is that correct?
That's correct, and I have no objection proceeding with both
Well, I'm going to try.
at once. I have no problem with
We've
that.
had a lot of pleas today, so I've been doing advice rates all day. So both parties did sign advice rates forms, but I'm just going to verbalize those on the record today. So the plea offer for both of the individuals is that they will plead guilty to count 1, larceny from a motor vehicle. And no, they're going to be pleading no contest.
That's right, thank you, Judge. Yeah.
Okay. All right. So I'm going to wait out the guilty.
I did initial that, and I did check that, and I did.
I'm just going to wait out the other one.
First.
So I don't get asked about it. Okay. And then the prosecutor's office, Kilbrews to no upfront incarceration, correct? Obviously, if they violate probation, they could go to jail. And
100%.
then upon successful completion of probation, the charge would be reduced to a misdemeanor larceny, 200 to 1,000. So the felony would be dismissed. So is there anything else, Mr. Bandetto?
No, Your Honor.
Is there anything else, Mr. Noe?
No, Your Honor.
All right, so raise your right hands. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Mr. Horde?
No, we're all the way around, Judge.
Mr. Horde? You gotta speak up for me, nice and loud.
Yes, Your Honor.
All right, Mr. Walworth? Okay, now, there's a micro, you can put your hands down. See those microphones? Move them right in front of you. And then I need you to speak loud. Attorneys are loud. We are all loud, but you have to be loud too, so that we can hear you. And Mindy, who is my court reporter, can hear you. She's remote today. So, so I'm gonna start with Mr. Horde. You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1 larceny from a motor vehicle, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine?
Judge, I know.
No contest.
Yes, thank you.
No contest.
No contest.
All right, is it your intention, Mr. Walworth, to plead no contest to count 1 larceny from a motor vehicle, which carries a maximum penalty of up to 5 years in prison and or a $10,000 fine?
Yes, Your Honor.
So, and you understand, Mr. Walworth, you successfully complete probation, that this would be reduced to a misdemeanor larceny. If you don't successfully complete probation, you could be facing prison and or a felony on your record. Do you understand that?
Yes, Your Honor.
And the same goes for you, Mr. Horde. Do you understand that?
Yes, Your Honor.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Noe?
It is.
And Mr. Bandetto?
Yes, Your Honor.
And is that correct as far as you're aware, Mr. Horde?
Yes, Your Honor.
And Mr. Walworth?
Yes, Your Honor.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and a court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. So, and I'll ask the question, then I'll ask you each individually. So do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Mr. Horde?
Yes, Your Honor.
Mr. Walworth?
Yes, Your Honor.
All right, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Mr. Horde?
Yes, Your Honor.
And Mr. Walworth?
Yes, Your Honor.
All right, due to changes in the law, do you understand, gentlemen, if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. You used to be able to withdraw your plea, can't do that anymore. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with the order of a court pending sentencing. So if you commit a new offense, you violate bond conditions, you fail to appear for sentencing, this plea agreement goes out the window, but you don't have a right to withdraw your plea. Do you understand that, Mr. Horde?
Yes, Your Honor.
Mr. Walworth?
Yes, Your Honor.
All right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Horde, do you have any questions about the rights that I've given to you?
No, ma'am.
Mr. Walworth? So, Mr. Horde, how do you wish to plead to the charge that on or about February 21 of 2025, in this Madison Township in the county of Lenawee that you did commit the offense of larceny from a motor vehicle.
No contest.
And Mr. Walworth, how do you plead to the charge that on or about February 21 of 2025 in Madison Township in the county of Lenawee that you committed the offense of larceny from a motor vehicle?
No contest.
All right. Has anyone made any threats or promises to induce you to plead guilty to this charge? Mr. Horde and Mr. Walworth? Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Horde? Mr. Walworth?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea offer to induce the defendants to plead guilty? Mr. Noe?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Has your attorney, other than the plea agreement, promised you any particular sentence or estimated what your sentence would be? Mr. Horde?
No, Your Honor.
Mr. Walworth? All right, so Mr. Horde, is it your choice to plead guilty
No contest.
or no contest?
Yes.
All right, and same for you, Mr. Walworth? All right, so who's gonna place the factual basis on the record?
I can't, Judge.
All right,
Judge, kind of review the police report. It would show that on or about February 21st, 2025, Madison Township, County of Lenawee, State of Michigan, that both my clients were in that locality. That there was some that they were working at or near Neil's Towing, and that they had access to some vehicles there that currently still belong to the owners, but were in the possession of Neil's Towing at the time, and that they went to those vehicles, took some tools and some other sort of things out of those vehicles that were in the motor vehicle, that were owned by the owners, but again, were in the possession of Neil's Towing, and that they didn't have any permission to take those properties from either Neil's Towing or from the registered owner of those vehicles, and that's it. Actually, I don't know.
any additions or?
I'm satisfied. Yeah.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on February 21 of 2025 in Madison Township in the county of Lenawee that the defendants did commit the offense of larceny from a motor vehicle by entering the property of Neil's Towing and taking tools and other items from vehicles that were in Neil's Towing lot without permission of the owners of the motor vehicles. Has the court complied with MCR 6.302 B, C, and D? Mr. Noe?
It has.
And Mr. Bayonetto?
Yes, Your Honor.
Accept the pleas. They've been given understandably, voluntarily, and accurately. The defendants have full knowledge of their rights. They do have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendants, or anyone acting in the interest of any of them, although the court will, as long as all terms are complied with, honor the Killebrew plea. I'm going to refer this matter to the probation department for a pre-sentence report. Mr. Noe, I am setting things in restitution for the record is to be determined. Is that correct?
Yeah.
Yes, Your Honor.
Okay, so Mr. Noe, the sentencing date I'm using right now is September 5 at 8:15. Are you available that day?
Yeah, I'm in front of you anyways on a civil pretrial at 9, so that's perfect.
Okay, so I'm going to set sentencing for September 5 at 8:15 in the morning. There is a recommendation of no upfront jail. So Mr. Horde, you do have the right to be present in person, but you can appear via Zoom. What would you prefer?
Zoom.
Okay, Mr. Walworth, you have the right to be present in person, but you can appear via Zoom. Mr. Noe usually has his client Zoom from his office. So do you wish to appear via Zoom or in person?
Zoom's fine.
Okay, so that will be Zoom. Now, yes?
I'm so sorry. Mr. Horde is assigned to Judge Olsaver, so I don't know if he needs to waive anything.
My client would waive.
Why is he on my docket?
Because they're co-defendants, so we got the ball rolling last time at the last pretrial arraignment. Cause to consolidate.
Okay,
You know,
so
he had the lower number.
Your client has the right to be sentenced by the judge that took the plea, or he can be sentenced by the judge that is assigned. Does your client want to be sentenced by me or by Judge Olsaver?
We would waive and have this court sentence both clients.
All right, so I will sentence him. So Miss Adams, there you go. Thank you, Miss Adams, for catching that. All right, so we'll set sentencing for September 5 at 8:15 via Zoom. So gentlemen, I'm going to need you to step across the hall to the probation department and check in. They're going to set up a time to meet with you, probably separately, and then they'll give you a packet to fill out. Make sure you fill out the packet, make sure you show up for the meeting with them, be truthful with them about your background, the events that occurred.
I would judge just about the events that occurred because it is a
no contest, you don't have to say anything. I don't get them very often. So you don't have to say anything about the events that occurred, and it's for civil liability, right?
That's right.
Okay, and they'll prepare a report. We will provide that to Mr. Noe. He's really good about reviewing them with you in advance. And then we will see you back on September 5 at 8:15 in the morning. Anything else? All right, gentlemen, just step across the hall. Thank you, Mr. Noe.
Thank you, Your Honor.
I think that's it for the docket.
I believe that does conclude no, I have Morse. What happened with Morse? It's on page 5. Thanks, Charles.
Have a good day.
You too.
Violation of probation?
Yeah.
Yes.
No. Okay. Well, I do believe that concludes our criminal docket. And so you might want to go down and see what's going on with the trial. It's more exciting than I have no docket now. All right. Bye, Alex. Thank you. All right, everybody. Have a good day.